Well, Mr. Martinez, what do you make of the fact that 1415F uses the term remedies and then also uses the term relief?
Are you talking about the 1415L, the exhaustion provision?
I'm sorry, yes, that's what I'm talking about.
I think that I don't make much of that, Your Honor, because I think that whatever remedies might mean, relief really only has one reasonable meaning here, and it means the specific remedies that you can get at the end of the case.
Well, why would they, compensatory damages is a remedy. Why wouldn't they use the term remedies there?
I think they could have used the term remedies there, but I don't think that they had to. And I don't.
It's just elegant variation.
Yeah, and there are other places in the U.S. Code where you have these terms remedies and relief used in close proximity without any reason to think that they mean something different. You know, two examples I'd point you to, Your Honor. These aren't in the briefs, but 18 U.S.C. 3626D, 28 U.S.C. 3306. Like, these statutes sometimes just use these terms interchangeably. The other side says that remedies actually has a different meaning as well, a means of enforcement meaning, which I think got a little bit of discussion yesterday. But even if that were true, that wouldn't affect the statutory term at issue here.
How have the courts of appeals interpreted this provision?
The courts of appeals have generally not agreed with our first argument, which is that the text of the statute has to come out our way, although I would note that two of the courts of appeals have done that, although they've acknowledged that our side has the better textual argument. I think the First Circuit and the Fifth Circuit have said that. Judge Bumate's dissenting opinion in the Ninth Circuit, I think, makes the same point pretty well. The courts of appeals have generally agreed with us on our futility argument, which is that the settlement constitutes futility. And I think that one thing that's important here is we have a bunch of different arguments, and they're kind of confusing. It's confusing to kind of distinguish them. I think that one thing that's really important here is to look at the net effect of Sturgis's responses. And maybe you could think, okay, they have a fair point on this argument or a fair point on that argument. But if you step back from all of it, the bottom line position, the bottom line place that Sturgis arrives at is that a parent who does everything right, Miguel's parents and Miguel, they did everything right, they accepted the settlement, they lose their ADA claims. That just can't be right. I mean, imagine, put yourself in a parent's position. They have wonderful claims under both the IDEA and the ADA. Say their child has been denied a FAPE, sent to a room for disabled children, and there has suffered medical injuries. They've got claims under both statutes. And then the school comes to them and says, okay, we know you're desperate to get a new IEP, desperate to remedy your immediate on-the-ground denial of FAPE. We're going to give you that. What do you want the parent to do? What does Sturgis want the parent to do? Apparently, Sturgis there are two answers. Number one, you can accept the settlement, but the price of accepting the settlement, even though the settlement doesn't give up ADA rights, is to extinguish your ADA rights.
But when you have a situation like this, the result, the nature of the settlement could reflect a strategic choice on the part of both parties. It could also reflect bad lawyering on the part of one or both parties.
Right.
If it's the latter, why does this case make that much difference?
Well, I think that—
I mean, the parents' attorneys, maybe they may not be that sophisticated, but they could have, both parties could have discussed whether they wanted to wrap up the whole thing in the settlement. They could have done that. Or they could say, well, no, we're not going to do that, and we'll take our chances later in litigation.
Well, I think your point about how the settlement negotiations would play out is extremely important, and I think it favors us, because our rule would allow the parties to come together. If they can reach a global settlement of everything, terrific. But if they can only reach a partial settlement, if they can only reach a settlement that addresses the IDEA claims, our rule would say, yes, of course, in that case, the student and the parents should accept that settlement, get the on-the-ground FAPE relief immediately, and then the parties can agree to go on and fight about the ADA claims for relief later.
I mean, the settlement could have specifically preserved the other claims, too.
Well, I think under their rule it could not, because under their rule, if you accept the settlement, you automatically extinguish your ADA claims. So our rule allows the parties a sort of freedom of contract. Their rule says if you're not willing to give up the ADA claims, you can't get anything by settlement, because the effect of the settlement is to give up everything. That rule doesn't make sense.
Thank you.